Number 8 from your political science book of grade 12, and the name of the chapter is organs of government, that is the judiciary. And today we are going to complete this chapter in this video. So judicial restraints, or you can say the powers of the Indian judiciary to issue writs. So while guaranteeing the fundamental rights of the citizens, the Constitution of India also grants the right to constitutional remedies. It is designed to protect the fundamental rights against the violations, and grant the fundamental rights would have remained meaningless without the incorporation and with this right under, you can say, uh, article number 32 of the Constitution. Article number 32 grants and guarantees to the people of India the right to move to the Supreme Court for the enforcement of the rights as confirmed by Part 3. It empowers the Supreme Court of India to issue writs, is including writs of the nature of habeas corpus, mandamus, prohibition, quo warranto, and statutory for the enforcement of the fundamental rights. This power is also available in article number 226 is to the high courts working at the intermediary level of the Indian judiciary system. Article number 32 provides a guaranteed remedy for the enforcement of all the rights conferred in the Part 3 of the Indian Constitution. So, what is habeas corpus? So habeas corpus, or you can say the writ of habeas corpus, it is a Latin term which literally means if you may have the body. Okay, while the proceeding, proceed the detained person in the court and explain the grounds of his detention or arrest. It involves a remedy against unlawful arrest of any person by any prosecuting authority. It is intended to secure the freedom of an unlawful detention of the person. The Supreme Court of India, as well as any high court, can issue writ of habeas corpus. It is a direction of the court to a person who has been detained, who has been detaining other person. It commands the detaining person to bring to the detained person in the court or for explaining the grounds of his detention. Okay, so you can say habeas corpus is designed to secure the fundamental right of a person against the violation of the right to freedom, that is article number 19. Okay, right to protect the life and personal liberty, article number 21, and right to protection against arrest and detention, article number 22. So all these are the, you can say, protection. Article number 19, 21 and 22 is getting protected by our writ, that is habeas corpus, which is written in our article number 32. Okay, but other than that, if there are some other cases like TADA, POTA, that is TADA, TADA, POTA, POTA, MISA, these are, laws which under which they can detain if they are, these are the black laws, and if under this anybody is detained, then no habeas corpus will be working against this because they are suspected to be the terrorists. Okay, next we are having a writ of mandamus. Mandamus is again a Latin word which means we order. The writ of mandamus is an order of the Supreme Court or the High Court commanding a person or a body to do that which is his duty to do. Usually it is an order or direction to perform, directing the performance of ministerial acts, that is an act which a person and or body is legally required to perform under given circumstances. By this writ, the court can direct the concerned authority to do his legal duty. By this writ, a lawful and duly selected candidate for a job can get such a writ for his appointment and from the legally competent authority or person. So it is upon the satisfaction of the conditions that the court usually issues a writ of mandamus. As the purpose of this writ is to enable the people to get their lawful rights or claims securing from their appropriate person or body. Okay, next we are having the writ of prohibition. A writ of prohibition is issued basically for preventing an inferior court or from extending its jurisdiction or from acting contrary to rules of natural justice. It is issued, for example, for preventing any judge from hearing a case in which he is supposed to have a personal interest. This writ is used by the Supreme Court or the High Court to prevent any magisterial court or commissioner or tribunal or any other officers who have involved in the excess of the judiciary powers affected the property of a right to the citizens. Such a writ is issued against a body exercising public functions of the judicial nature and quasi-judicial nature. And it however cannot be issued for restrictions and exercise the legislative power. Through such a writ, the Supreme Court also supervises whether the inferior court or the tribunal have been acting with the jurisdictions and is conforming with the principles of nature of justice or not. Writ of certiorari. So the writ of certiorari is issued by the Supreme Court or for removing a particular case from an inferior court. It can be issued even before a trial for preventing an excess or abuse of jurisdiction by an inferior court. Or the concerned case is then moved to the higher court for trial. It can be issued after the trial or by an order which had made without the jurisdiction or in deficiency of the rules of the natural justice. Very often a writ certiorari is south or you can say is along the writ of the prohibition and for prevention of the performance of an invalid act. Okay, next we are having the quo warranto. It is an ancient writ which has been in use since long in the common law process. It literally means what is the title of authority. The Supreme Court or the High Court can issue this writ for granting an injunction or to restrain a person from acting in an office to which he is not entitled. And it can also be used for declaring an office to be vacant. And while issuing the writ of quo warranto, the court has to ascertain certain whether there have been in a you can say there has been an officer in the public nature or not. Okay, the fundamental purpose of this quo warranto is to ensure that the public has an interest to see that an unlawful claimant does not prevail or does not develop in a public office. Okay, what is the judiciary in the liberal democratic political system of India, UK and the USA? So India, UK and USA are the three liberal democratic political system, and so in each of these the judiciary enjoys a very important and powerful position. Each has an independent, impartial, honest and efficient judiciary. So separation of judiciary from the other two organs of the government and makes these three countries really efficient in the judiciary system. In India, judiciary enjoys an independent constitutional status as it is neither a part of the executive nor the part of the legislature, and it is neither under the control of the executives neither the control of the legislature. In other words, we can say it is totally independent. The Supreme Court of India is the apex, is the highest court of the land, and takes the final decision. The judicial administration is organized, run, and controlled by the Supreme Court of India. So, India and USA are federals. Okay, are federations, and yet the structure of judiciary system differs in the two. In the USA, there is at work of two-tier judiciary system. One is the federal judiciary system, or you can say the federal courts, which decides the case and involves interpretation and application of federal laws, and the state judiciary system, under which each state of the federation has its separate judicial system, which decides cases involving and interpreting the applications of laws of that state. In India, there has been at work a single integrated judiciary system, which is head of by the Supreme Court of India, with High Court working at the state level and District Court working at the local levels. The courts interpret and apply both the laws of the union as well as the state government. The India Further, we can say that in India and in the USA, judiciary acts as a guardian, and who is guarding the fundamental rights and freedoms of the people. The Constitution of India, in the Constitution of India, Bill of Rights, that is Part-3 of the Fundamental Rights, stands incorporated in the Constitution. Thus, there are both structural and functional similarities and dissimilarities again between the India and USA. And we are finding that USA judiciary system stands organized under the provisions of the US Constitution. However, it has evolved into a full developed judiciary system during the past 220 years of its work. Each country of the judiciary in each country, the judiciary has been serving well and the needs of the society. Hopefully you understood. Thank you.